Motion to withdraw the honors counsel.
Why?
Well, for one thing, he's not going to pay me anymore, I don't think. I've been got paid for a number of months. And, we're supposed to be coming up to trial.
When is this trial set? When was this on? Please. June 2nd? No, that was the last.
That was the last
event.
meeting. I don't think he had the present setting. I don't know what.
No,
We had hearings.
setting for the hearing, I forgot to be raised.
Yeah, we had the last trial setting was in March, Judge.
And this is this is 2.5 years old, and now we're not getting paid.
I just worked with him, tried to get payment, and now he doesn't pay. He hasn't paid for several months. I'm not sure what his problem is. He never talked to me about
I don't get involved in this, but is there a problem?
Yes, very much so.
What is it?
It's black and white. None of the things that I've asked him to do have been done. There's no motions on my end. We're here. We're at 2.5 years later. You said it yourself. I mean, it shouldn't be going to trial. It's a waste of money for the state. It's a waste of money for myself and time. It's all started with the police investigation. I've never.
Right away, you can tell this isn't just a simple fee dispute. The defendant is arguing that critical actions were never taken, while the attorney is focused on unpaid bills. That's a dangerous combination in any criminal case. When communication breaks down between lawyer and client, trust usually becomes the first casualty. And here's something to think about. If your freedom potentially depended on someone, would you continue working with them after months of frustration?
I could believe once. I've never talked to this man to be able to talk to him to get through the state and say, hey, this doesn't need to get de-escalated. We need to save the state some money.
I don't. That's wonder. He should know this is an aggravated assault case. Either assaulted guy, or he was self-defense.
When did you get fired, please?
I got paid for it today, and then he was retained May the 24th.
May the 24th.
Of what?
2023.
Okay, 2 years.
2 years.
So 2 full years goes by, and now you're filing a motion to withdraw because he hadn't paid you?
In a while. I think the last time he paid me was before December.
Right.
He thinks probably he paid me too much. I don't know. I don't know what the heck he's talking about as far as motions. He wants to talk to the police. He doesn't have the right to talk to the police. And it's if he asked me more fundamental questions, maybe I could explain it to him. But now I've got expenses. I've got to travel. He's known since December that I've been moving to Longview. It cost me some money to come down here and try the case. So I was just trying to get it's going to be a 3-day trial. And he needs to at least pay me for the 3 days of my expenses.
It's also been my experience that sometimes you end up getting stuck as an attorney. And it's not a good deal. It happened to me when I was in private practice. You get stuck, and there are all legal ways of handling that. But what disturbs me is this has gone 2.5 years, and now I'm looking at I'm being presented with something that is far overdue for trial, and y'all are bickering over a civil contract that isn't being worked out.
Well,
That's not for the court to resolve. It's not for the court to resolve. You got a problem with him? There's a bar. There are agreements that you want to file.
I completely agree.
If that's what you want to do, you assume a responsibility to represent it, and that's you can't do 2.5 years really, and then whatever money has been paid, I don't know.
Notice how the conversation is shifting. The attorney isn't only talking about legal work anymore. He's talking about travel costs, expenses, and the practical realities of representing a client. Many people assume lawyers can simply quit whenever they want, but courts often look at timing. And when a case has been pending for 2.5 years, judges tend to ask one question first. Why now?
I don't want to get into that, but some money had to have been paid.
Yes.
And this is overdue for disposition. And what we're going to do things. I can release you, then we have to start over with another lawyer. And that would be fair to the people, which is my first responsibility, as well as the constitutional rights of defendants. But moving a trial forward without unreasonable delay is foremost. And I don't get these problems. These are always worked out. But I also know lawyers end up losing money on some cases. It's a responsibility, though, that they deal with. If you're indigent, are you indigent? Are you able to pay? Do you have a job?
No, I beforehand I did have a job. Now circumstances have changed. I don't have a job. I haven't had a job for the past 5.5 months. I'm working on getting a job. This is delaying on me getting a job.
So you don't have an income right now?
No, I do not have an income.
All right.
I didn't understand. I didn't know that.
All right.
Fully. I know I gave him a little time because you should find jobs.
He can look.
Yeah.
You.
But the thing,
You can continue to. First of all, you've spent the time. You've gone down the road on this. I'm not going to start over. If you come.
This is where the hearing takes a major turn. The judge isn't focused on who owes who money. He's focused on the bigger picture, keeping the justice system moving. Courts have a responsibility to protect defendants' rights, but they also have a duty to avoid unnecessary delays. That's why the judge immediately starts asking about the defendant's financial situation instead of debating the payment dispute.
To me later and apply for indigent funds to help you in this case, I'm happy to consider.
Sure.
And it doesn't happen often, but it's happened before, and those have been granted. Reasonable fees have been granted, but I want your 2.5 years and yours. Y'all fix this together. Work together, please. It's in your best interest. It's in your best interest.
I didn't know I could apply for it.
It doesn't happen normally, but there's always an answer to every unique situation that this court over 18.5 years has had to deal with. But we just don't open the door for the people to pay. Y'all work it out. But if his situation has changed and he's unable to pay, then he needs to fill out an indigent form before he leaves, so that can get into the record. If it changes, you have to let me know, or else you're in trouble. So you get a job, fine. You start accounting for your time that you would ask for reimbursement for while he is indigent. But this moves forward, please. I'm going to be kind about it. I'm demanding I'm ordering it to move forward. Y'all had enough time to prepare, get to the finish line one way or the other, however this is going to be disposed of. Okay? Is it Mr. Hammonds? This doesn't look like a real complex matter. It could be, but
I've got to go down to 3 witnesses, Judge.
There's no reason to delay 2.5 years on 3 witnesses. Come on. Now, y'all's business is yours, but the state, it's succinct. It's obvious.
The only thing that is 2 of my witnesses will require an.
Did you catch that? The judge just offered a compromise that neither side seemed to expect. Instead of allowing the attorney to walk away, he's suggesting possible indigent funding to help cover future legal work. That's a creative solution aimed at solving the financial problem without blowing up the entire case. Sometimes judges aren't just referees. They become problem solvers when the system starts grinding to a halt.
Interpreter.
All right. And if it's not going to be disposed of by a trial, let me know so we don't spend time and money preparing for a trial. If it can be worked out, let me know. If not, let's try it. But what's it set for, Helen?
I can put it on the 25th when Mr. Cobb is here already.
No, he's not going to be ready. I'm going to give me another month, please. We're setting this, y'all. That's the finish line.
The 22nd of September.
Okay. That's
July 22.
okay.
All right, that's set on that date.
We'll make sure.
If
We'll
I
work together.
correct, if I may say, one of the things that I want to bring up, obviously that was a sideline for me from
Yes,
the get go. I want to bring up. I also want to get this over with and situated, which I want to talk to Mr. Cobb, see if we can continue this, because in reality today, I got served with this paperwork on the 24th, just the other day, saying this motion for him to get out.
Yeah.
But we realized this before in our previous time that we came here, when he didn't show that he wasn't going to no longer be here to partake in this. I came here on my last continuance. I was never even called up here. I showed up in the morning. I was on the court docket online. No one gave me an explanation. I just waited for the bond people to call me. I mean, I don't know how it slips through the cracks or who get
Well,
but at the end of the day, I'm here.
Try to explain that.
Look, when motions are presented, when motions are filed, that doesn't get my attention because I've got 2,500 cases, 2,500 cases. So lawyers know they can file a motion, but I'm not going to even know about it
Right.
unless it's presented. We call it presented. They've got to present it to me, get my attention, and get everybody together, and then
Right,
I will conduct a hearing on it. The fact that it's filed, that doesn't get to the finish line.
Right.
You have to present it, and then we'll take it up. It would be enormous. And most motions, strangely enough, are never presented. They file them, and they sit in the file, and then they get shredded at the end because nothing was ever done about it. Nobody ever presented. Nobody ever moved on it. They filed it. It seems to me a little.
Now we're hearing the defendant's frustration, and it's not really about money anymore. He's talking about missed appearances, confusion over court dates, and feeling left out of the process. Whether those concerns are justified or not, perception matters. A defendant who feels unheard is far less likely to have confidence in the legal system. What do you think is more important here? Preserving the attorney-client relationship or keeping the case moving as quickly as possible?
A waste of effort, but until it's moved by the parties, when the party presents it to me, we have a motion, we want to have a hearing on it, then I'll do it. Because most motions they're filed and then they're never moved on. And that's the party's business. So that's what the court does. I couldn't deal with all those on my own anyway. It would be impossible, but it's unnecessary because they're pro forma. They're some just formality in many cases.
Hold on a second. Did you catch what just happened? After listening to both sides argue about payments, delays, and responsibility, the judge just delivered the message that changes everything. Work together. In legal terms, this is the court signaling that it's losing patience with the drama and wants results. 2.5 years have already gone by, and from the judge's perspective, enough is enough. But here's the question. If you were the defendant, would you still trust an attorney you were actively fighting with? Or would you want new counsel no matter the delay in
And until it gets serious, then I'll be able to move on. In y'all's case, work together. The team is more powerful than.
After nearly 3 years of delays, the judge has drawn a line in the sand. The message couldn't be clearer. Either resolve the case, negotiate a deal, or prepare for trial. From the court's perspective, this isn't really about attorney fees anymore. It's about preventing justice from sitting in limbo indefinitely. And honestly, this is one of those moments where everyone leaves the courtroom with homework. The lawyer, the defendant, and even the prosecution now have a deadline they can't ignore.
Individuals working in different directions for the same goal. You represent him, and you got your interests here that are at stake in your constitutional rights. Work as a team. That's the way it's always done. We never have problems. Fix this. And that's in your best interest and everybody's best interest. Okay? It's set for trial. If most cases are disposed of without a trial, 95% or disposed of without a trial. If that's the way it's going to be done, let me know, and then
That's the route that I
we'll
would
move it.
take.
If it has to be a trial, we've done 600 trials,
Yeah.
so we're not afraid to try cases. That's what this is for. Okay, fix it. Be ready for trial, or let me know otherwise.
Thank you,
Okay,
Commissioner.
thank you.
What started as a dispute over legal fees ended with a judge focused on one thing: moving the case forward. No dramatic withdrawal. No starting over from scratch, just a clear warning that the clock has already run out on excuses. The bigger takeaway here isn't just about this defendant or this attorney. It's about how courts balance fairness, efficiency, and the reality that justice delayed can become justice denied. Do you think the judge made the right call by forcing the case to continue? Or should the attorney have been allowed to walk away? Drop your thoughts below. And don't forget to subscribe for more courtroom breakdowns.